And the question that usually comes into play is, how much work did you put into it? Who put in the most work?
Jacqueline Waihenya, advocate of the High Court of Kenya, dispute resolver, chartered arbitrator, chartered mediator, governance expert, patent agent with Kenya Industrial Property Institute, vice chair of the Institute of Certified Secretaries, chairperson of the Kenya chapter of the Chartered Institute of Arbitrators.
With AI, we don't know whether the machine is now going to be considered to have some sort of legal identity, and those questions are still in the air. Now, artificial intelligence is intelligence that is done, I think, through machines, through computers, but it mimics human beings. Even when you use a tool, make sure that the source is something you can trace and know that this material is not copyrighted. Let us remember, even when the internet was formed, we said that the internet was free, the internet was forever, the internet never
forgets. I'm really glad to have you here.
Thank you very much. And thank you for inviting me to Converge 3. I found the subject very interesting, artificial intelligence. And of course, what we can do about it is a very new area at cutting edge.
So one of the key issues that was raised was around privacy. So what would you consider privacy in the general digital space? And how does that differ within privacy in the AI space?
With the general digital space, I think we call it now the digital ecosystem. This comprises of people, networks, businesses. And generally what happens is that privacy within this space really relates to a particular issue, and it is directed for a particular purpose. So you register to get into a company's website, give your names, and the network will be able to assist you in whatever way you require in that particular space. AI is dramatically different because it's all these machines that are communicating with each other. Now, artificial intelligence is intelligence that is done, I think, through machines, through computers, but it mimics human beings. And when they're talking to each other, the main case use that we have been seeing, because they're generating AI, is that we are looking and experimenting to find out a purpose. So privacy within the AI space then differs because, first of all, the scale is so much bigger. The purpose is completely different. And everybody who is involved in this particular space, let's say the people, they are those who manage the generative AI. They know what is happening. Everybody else has absolutely no idea. There are these terms that we are beginning to learn, like data scrapping, which means that they're looking at whatever is happening in the internet within the machine, so that when they're talking to each other, and privacy in that context then becomes very blurred. So the scale and the purpose is what differs within the two platforms.
When we define data protection in the AI space, then how does this also differ from whatever is happening in the general ecosystem?
When we look at what is happening in the general ecosystem, we now know when you're talking about privacy, we're looking at a restricted use, and it's restricted for a particular purpose. When we now look at what is happening out there, I'll call it out there because we don't really know what is happening in that particular space, we are not really aware. Now, generally speaking, privacy and data protection are two sides of the same coin. So data protection then looks at ways of protecting your interests, with mechanisms, so that we know who is a data controller, a data creator, and they are licensed to do specific things. Privacy is a key issue. Of course, identifying, protecting, and then also ring-fencing it so that the licensed purpose is what ends up being used. With AI, many things go out the window, and we are now trying to understand what does privacy within this space mean? What does data protection in this space mean? We are not yet able to register the owners of AI. And I think it's also important to mention AI, the machines. We even refer to the machines as AI. So who is it? Who are the persons? Is there personhood? Regularly, the regular law, or currently what we are using, recognizes a human being a natural person, that is me and you, and also the persons that we create by law, like companies or entities. With AI, we don't know whether the machine is now going to be considered to have some sort of legal identity, and those questions are still in the air.
So we've seen a lot of evolving risks, the needs and the possibilities that are taking place in this space. So how should we go about establishing responsible policies for AI, and what should policymakers be considering at this time and point?
At this point, the best way, because we're saying we don't know a lot. The first thing is to start classification. I've mentioned about person. What are we going to do about that question of personhood from a legal perspective? But it doesn't end there. There's also this huge issue about the AI black box. We do not know what is in that black box. We are told it's complex and it is difficult. We need to break down the black box and figure out how each component affects each of our legal rights. So that is one area that policymakers should be on the lookout for. So we have existing laws. If you take the example of Kenya, we have the Constitution. We already have privacy protected. Even your communication is protected under our laws. That's Article 31 of the Constitution. But privacy in Kenya is not an absolute right, because there is also the right to access to information. So those two rights will of necessity have to compete against each other. There is a question of greater good. Yes, AI does have many, many positive things, but there are also opportunities for misuse and abuse. So identifying the misuse and abuse is also a critical legal function that needs to go into our laws and also into the policies, the guidelines, the soft law, if you like.
Has digital law caught up with the digital protection needs that you've talked about? And how does this compare in Kenya and in Africa and even globally? What is happening?
I don't want to be a pessimist, but digital law, the legal framework, is still playing catch up by a long shot. And when I say catch up, it's still trying to catch up with the digital ecosystem. Remember, the people, the networks, the companies, everybody who has a commercial interest. So, and no sooner does digital law catch up and the rest of the people, particularly the inventors, the coders, the programmers, they're on to the next thing. So the framework is sufficient to deal with our general privacy and data protection requirements. However, we still have a long way to go. Now, I will highlight the cybercrime, because we do have a statute. It's based, I think, they call it the Maputo Convention. Mm-hmm. There's also the Budapest Convention. The Maputo Convention is African, done by the AU, the Budapest one by the EU. Our cybercrime framework in Kenya is actually based on those two conventions. So Kenya is really up to speed in those two areas, in those two conventions. When we look at data protection, I think we've also gone very far compared with other jurisdictions, because we do have the Data Protection Act as well. It does a lot, but then when you contextualize with the new changes that are coming, those that we know and those that we also don't know,
and there are many,
bit inadequate.
So you know a couple of countries within Africa, such as Mauritius, who created their AI regulation in 2018, and a lot of other countries that have been in the process. And there's also the draft guidelines that have been developed by the AU. What can be done towards working towards developing these regulations? One of the things that we've seen may have worked for different elements is regulatory sandboxes. What role would they be playing in this?
Okay, regulatory sandboxes are a very useful tool to be able to guide the investment in AI for Kenya. Also to guide the dynamics when we see what is happening and what people are investing in, then regulators are able to sort of have a microscopic view and be able to work with the inventors as they are making their developments. And the sandboxes can also be very used to also make a commercial case for the use of AI. So the importance cannot be gainsaid. I think that is the first step to go. And then as we move along, there's no way we can work without dealing with this issue from a multi-stakeholder point of view. Of course, the big five, the big American companies, there are other governments, and of course working together because of cross-border flows. So this effort cannot really be a Kenyan effort. It also has to involve the AU, African countries, and other players, other regions like the European Union, the UK, and the United States. China is a bit of a question mark because they do a lot of surveillance. They do have a lot of mechanisms and techniques and innovations, but it still remains a very crucial.
Okay, so even as we're talking about the regulatory sandboxes, one of the key issues that you'll see when the guidelines for regulation are being developed or have been developed, they mostly focus on key industries. So they'll talk about agriculture, they'll talk about manufacturing, they'll talk about education. So a key thing that we've seen that is missing out is what happens to the creative economy, which is where there's a lot of output in terms of development of new ideas or creative works. How would this work within the regulatory sandboxes? Is it that we have to go an industry-specific approach, or how would we do that?
We may not be able to avoid going the industry-specific route, because like now we've just come out of the Big Four agenda. Of course, there was housing, there was manufacturing, there was health, agriculture. So we know that is the focus where the government has been looking. And what tends to happen is that where government funding goes is where you find investment is also.
Yeah, that's true.
So it will definitely be driven by those considerations. But for creatives, because this is your industry and you're going to be in this industry for the foreseeable future, it is also important to identify in which areas the shoe pinches, in which areas also you can make significant strides that can have a financial and commercial impact.
One of the things that we know that has been taking place with AI is the data scraping. So where they collect information. How do we ensure that there are policies around the right to forget for permeative systems like AI?
Well, the right to forget, this is in the GDPR, General Data Protection Regulation of the EU. It is also incorporated into our data protection. It basically just means the right to erasure. What does the right to erasure entail? It means when you go onto a website, you've given your consent. And our consent is usually very automatic. Just hit the accept cookies. Nowadays, they have nice ways of saying it, say okay, say managed, so all those preferences. So once you give that consent, usually it's very wide-reaching. What in theory and by the instruments, soft law, and also now by our act, what that means is that this right to erase means that you can go back to the website, you can go back to the organization and tell them to remove your consent. Now, with the digital ecosystem, if you had just put in your data so that you could register, get a particular service, requesting for that erasure to be done should be an automatic issue that anybody can avail themselves, fill in a form, get in a response, then you know your data has been erased. Now, with data scraping, however, and let us remember, even when the internet was formed, we said that the internet was free, the internet was forever, the internet
never forgets. Yeah, that's true. But what happens for creatives? So, for example, the assumption is that the different AI tools, visual or audiovisual tools, would be picking on already created elements. So I've put up my photos or my videos over the last 15, 20 years. And those are some key points of reference. For example, if they're trying to establish what a tea farm looks like, I've taken a couple of photos in Kericho. So is there any opportunity for me as a creative to do any of that erasure at this time and point? Is it too late, or what happens?
Now, if that your photos are on social media, and I think social media is an issue that all of us, not just the creatives, also are going to have to really think about. If they're on social media, like I said, there's always that digital footprint. that remains, that is residual, if it belongs to you and you can demonstrate that you're the one who generated content, it is original content, and you're the one who was the first to come up with it, then you have a right that can be protected. It should be protected at the global level, at the regional level. In Kenya, at least, we can always refer to our constitution, and the right to property is guaranteed. It is yours. If that right is breached, then and if there has been somebody who has used your material for commercial gain, ideally, therefore, you should also be able to sue them for compensation.
There's a lot of assumed privacy infringement within the AI space. Is there any way, or how can we basically protect ourselves against that?
But there are two perspectives.
Mm-hmm.
When you use an AI-powered tool, you could be using material that has been generated by somebody else. Mm-hmm. Because of data scrapping, you may not even know where it originated. Now, when you're using that material, if it's for educational purposes, for scholarship, also for news and satire, those sort of things, generally do not attract any censure on you or any claim against you. But the minute you start making a commercial gain out of it, you're selling it to someone, you've been paid for it, then unfortunately the question of infringement comes in, and the owner, the proper owner, may emerge out of the woodwork from wherever it is that they come from and claim what benefit that you have been able to get. So you have to be careful about infringement. So even when you use the tool, make sure that the source is something you can trace and know that this material is not copyrighted, is not protected by another person. Of course, you could also come up with something that is original. You should also be able to protect it against third-party infringement as well. And the techniques, the tools that we have available, they're available in Kenya and also around the world, is protection of intellectual, but using copyright, trademark, and also we call them trade secrets if that comes into play, and also through contracts and agreements.
The big question that was there even during Converge 3, and we've seen a lot of conversations, especially within the creative space, is would creative work generated through AI be considered intellectual property?
So tempted to say no. But the truth is, we are really in a world in flux. What was not possible yesterday is now becoming possible because of new considerations. You may have invested in the AI tool. It would be really, really good if you're the one who invented the AI, the inventor, then you can have full claim to whatever work is generated. Obviously, if you're using or you're the second user, then you also would want, and the question that usually comes into play is how much work did you put into it? Who put in the most work? If it is a machine, the US has said, forget it, there's no copyright in anything generated by a machine because their law talks about
the human authorship element here.
Who has authored literary works, art, music. Here in Kenya, we might be a little bit more flexible because the word we use is person. A second user, I mean, you're not the one who invested in the generation. You're not the one who put the platform together. You're not the programmer. So you're really using an app to better your work or come up with a certain output.
Starting with the creators and the creatives, what legal considerations can they put in place to protect their work?
When I think about literary works, art, music, which is basically what you deal in, we're looking at copyright. But you should not rule out also trademark registration. The dynamic also depends on whether, at the end of the day, what you produce is going to be owned by you or your client. So with those two tools, then you should be able to have within yourselves, within your organization, at the very least, a policy and a strategy on how to use the tools and how to protect what you bring out as an output.
So I'm guessing the same would apply for brands and for agencies. So for agencies, I think because they straddle a bit of a middle ground whereby they're usually in contract with a client, that whatever is developed, the IP belongs to the client. So what happens in a situation, for example, the designer develops something out of Midjourney and that work is flighted, and at some point is a legal issue that comes around. Who is at fault in such a situation, and what happens in such a situation?
When it comes to legal dynamics, the answer is always it depends. And it will depend on what you have in your contract. Most contracts that I have seen will have work for hire within your industry. And they will say that you produce a certain output. Is it it's a brand? Maybe you're looking at I'll call it a picture, but that's art.
Yeah.
It could have jingles, that's music, and it could have some content, which is literary words. Now, when you put all that together, it then belongs to the company, your client, really. Now, for the agency, you'll also find that there's a non-disclosure agreement. And disclosure agreements are very interesting. What they say is that you cannot reveal, except that there are some usual exceptions that we have, whether this public policy, either required by government authority to reveal that information, or whether it is out in the public domain. Now, as a matter of public policy, usually we have a commission of crimes, and if you're found to have infringed, there's some criminal activity, the liability will come and rest back on the ad agency.
Oh, no.
So if you're using Midjourney and maybe Midjourney has artwork that you have scraped off or was scraped off. Because the truth is, if you read about Midjourney, even they don't know where half of the material that was used to train their machines came from. So the liability in Kenya will probably end with you. And then if you have a claim, you go back to Midjourney. So you have a nice domino
effect that feels very long
and challenging, because Midjourney has its own dynamics. You being sued is a quick win for your client.
There's some basic ways that you'd mentioned earlier that creatives can protect themselves. So are we saying, like, for example, especially because of the data scraping and the example that you've given for Midjourney, if I am putting out any form of photography that I've taken or any original works, creative work, whether it's literary work or music, how can I be able to protect myself consistently? Is it about putting a copyright? How else? What would that process look like?
I would recommend a holistic approach. What do I mean by holistic approach is to have an AI governance strategy in place so that you're consistently scanning what are they saying about AI and human rights. Of course, there's a huge clamor right now that privacy has to be observed. It's a human right, and people's rights should not be violated. The other question is, there's a question of ethics that arises also. I mean, how can these companies be doing this? Of course, privacy and ethics is one issue. But when privacy is breached and a particular person can be identified in that breach, then they get a right to sue. So you need to be very clear about where your data is originating from. So even as you're using Midjourney, yes, come up with the final output. Yes, work with it. It does help you and it does work to your advantage. But once you have the output, then you also need to look at that data asset. I think that's what they're calling it. That data asset, then do a background check. It really, really may save you a lot of money if you check and if you do those checks and you clear yourselves. So I'll give you a simple example, and I think we all attended Converge. We enjoyed it. I loved the photo. The Ferrari photo was really like the highlight. And I got to thinking about it and I was like, oh wow, this is interesting. But assuming you took that and you put it in some ad, maybe it's a fruit, Coca-Cola or something. The minute you do that, Ferrari is going to be on it.
And it sponsors anybody who has a sticker on that car.
Exactly.
Yeah.
And of course, you say you're doing it for Coca-Cola. They know that Coke has deep pockets and they can find them anywhere. So they automatically, you have a big, huge claim. Even the people in whatever it is that the people who are, I don't know whether they're from Kawangware, whether they're from Kibera or wherever they're from, you could actually distinguish facial features. And then if facial recognition software can be able to identify those people, maybe you have people, Kenyans, and you find a civil society group that decides, you know what, Onyango, so and so, Anyango, everybody Wanjiku, calling everybody Wanjiku. And then bring them and they become plaintiffs, and before you know it, there is also a suit against Coca-Cola.
Or the photographer who did a similar photo may come up and say that like this was reflected out of that.
So they're like, look, in that whole picture, the only new thing is
the fact, yeah,
and maybe the dust.
Yeah.
So I did 70% of that work is mine. I need to be paid.
But for that photographer who had done that work, should they have put, if they had put their work as copyrighted, they had put the C on their work, would it make a difference?
Make a difference if it's infringement of somebody else's work. But say, imagine the same photo was not a Ferrari, was a new age car that had been developed using AI, because you can do that. You predict that, Kenyans will be using this Toyota looking car, which is not a Toyota, but I think every car in Kenya,
is a Toyota, yeah.
So, you giving that prompt, then you come up with a car that looks new age, it's modern, it's fast, it looks like a race car, and give it a different connotation, and then have these people not distinguishable and doing something else. You never know, they could be running a marathon, So the Toyota car is as fast as the Kenyan marathoners, of course. We're famous for that. That is something that is now completely new and original. So this now, you can take that artwork and copyright it.
Okay.
Kobo will be asking you, it's the Kenya Copyright Board. They'll be asking, hey, did you do it? Do you have possession of that particular photo? Is it your original work? You have to demonstrate to them, it's not me, Jenny, that did that work.
Yeah.
You have to demonstrate that it is your own work. And I think moving forward, because we'll tend to use AI a lot more, the prompt engineering might come into play. So one of the other strategies that you must employ as, as a creative, whatever you do, document, write it up, and say, this is where I got this idea, this one I got this idea. Make sure you put it, because your computer's data everything anyway. Just keep it as a record, so that if any question ever comes, you'll be like, hey, wait a minute, you're the one who's copying me, not the other way around. Because I came up with this concept, I recorded it, here it is, this is what I did, this is who I did it with, and these are the resources that I put in place. So scanning your data assets will be a very, very critical part of your strategy. And now when you put them in place, then you will also ask yourself, is there a business case for protecting them? And when you say yes, if you answer yes to that question, then what is the steps, or what are the steps that I need to take to protect it from infringement now by other third parties?
We've had a lot of conversations, even during Converge 3 and even online, talking about one of the greatest fears around AI is people losing their jobs. So what are those future of work considerations that should be put in place in this AI era?
We can expect that AI will come and do many of the low skill requirements, or the jobs that have a low skill requirement. Jobs in the informal sector, I think there's some World Bank report that put it at 52% of the jobs that we currently have.
That's very high.
It's extremely high. But then you also have to look at the flip side of the coin. There will be all these new opportunities that also emerge. So the first step, I think I've seen some reports that suggest this. The first step is, of course, getting our children interested in STEM subjects. That's science, technology, engineering, and tech. So when they get involved in that space, and by the way, it is very minimal, do not have a large number of students who are doing this. Train them from an early age. Let them get interested in computer programming. Get them interested in using AI, generating AI, and also the different skills are required, because then the space is going to require so much skilled professionals. So as creatives, you want to also develop the tools and train people to use the tools. and then make sure that even those who are coming up the ladder are also exposed to these tools, so that you can also have the workforce that you require. So the future of work, the dynamics change every year. Also, then that means that even every year that you need to continue updating that policy.
So I think you've spoken quite a bit on the importance of organizations setting up AI strategies, etc. So as we're waiting for governments to develop and implement the regulations that we know they're going to come up with, and we know, unfortunately, more times than not, those regulations are trying to play catch up with whatever is happening. How can we self-govern in the process?
Well, self-governing will start by, first of all, not abusing the rights that you have, because you have elevated knowledge, and uphold privacy ethics. Well, there's a tendency to think, and this always happens in the commercial space, people always ask, what does the law say? What is my exposure? If it's an ethical issue, the tendency seems to be, you know what, let's just get the commercial advantages out of this. We will deal with the questions later. Everybody who is involved in AI needs to ask themselves the first question, the second question, the third question, and all these primary and secondary considerations must be adhered to. It is good that the industry is actually looking at self-regulation mechanisms. It's a good narrative. It is good if they are going to actually self-regulate, but I think it's a positive step ahead. So for anybody in this space, I think it's important that we consider those issues. Increase your skill sets, because the more we get skilled in this space, the better we're able to identify where we're going wrong or where we are going right. And then, of course, when we are called to engage in policy, let us engage. As a lawyer, I can tell you, anytime anybody tries to put out a policy for public participation, the people are involved never turn up. Please turn. Please share your concerns, and please make sure that they are addressed, and that's the only way that we'll be able to come up with policies that support the industry. And when I say industry, I'm talking about AI, but then also specific sectors or industries as well, and then also create the ecosystem, the future of work, making sure that the people who are in this space understand what is ethical, what is not ethical, and also create now a framework where they know if they breach this, then there will be consequences. That is the only way we can self-regulate in the short term. The long term, we also need to ask ourselves, what are the long-term effects? Of course, we all have lived through AI. We know it's coming. We have all been afraid of it. We have likened it to the apocalypse.
Yeah, the Terminator scenarios.
Long term, what is it all going
Yeah.
to be? Can we make it a happy ending?
Okay. I think one of the things we've talked about data protection, we've talked about privacy. One of the key issues around AI is also bias. How do we minimize that bias? Is it also part of it making sure that we are participating in whatever regulations would be put in place, or what else can be done?
CPIT, which is under Strathmore University, did a study recently. And the first thing they said is that AI, within the space of AI, there are no women. So gender bias automatically comes into play. And the numbers that they were giving is, I think, like 10%. So out of every 10 AI specialists, only one is a woman. So gender bias is an issue. For all the rest of us, the whole world, anyone outside of America, just know that culturally, AI is geared towards AI is US culture.
That's true.
The rest of us are playing catch up. So there's obviously that drive to Africanize. The beauty about Africanizing then is that because there's not so much data, no, we're not just talking about the facial features, the African, but things that are uniquely African, our cultures. And we have, I think, about 100 different languages in Africa alone. 75 of them have more than 1 million speakers. we do know that they are alive, and with each of those languages, there's culture that goes with it. So Africanization of AI is also critical, and bringing in culture. And then, of course, it's not just African culture. Also listen to what the other different cultures are saying, and how they can bring something positive to the cooking pot. The other biases are against, and this is really on facial recognition, because when AI is deployed, and for instance, you say that when they scrape the data, the African face is seen mostly within the context of prison
and poverty,
crime.
Yeah.
Then we also need to change that particular narrative. One other thing, and I think we also need to be very alive to this, and this is something that civil society will need to jump into. African governments sometimes use some of these terms negatively. So, for instance, there was
Huawei,
a safe city, and they have in place. Even in Kenya, we have that. What's a program or an app where it does face recognition. And at the very least, you'll find it at the airports around the world. But some, and I will not name them, some African countries have used it to is it called weaponization? Have weaponized it against their oppositions. We also want to see how we can curb such abuse. Yes.
That's so informative, and you've given us quite a bit of information to think through and figure out what the next steps are, unless you have any final remarks.
Well, the only final remark is really to emphasize AI governance and strategy. Please make sure you have that in place. Even if it's just to recognize, okay, do we have a definition of what AI is in our space? Do we understand what our assets are? And those that we have, what can we do about them? Once you understand that, even when you're going out there to engage with policy, then you're engaging with policy from a position of knowledge and not from, maybe perhaps that point of view.
Thank you, Jackie. That was a very informative conversation for us guys to have unpacked those legal considerations, what privacy looks like, what data protection looks like, what people in the creative industry should be doing to make sure that their stuff, the work that they're actually taking time and effort to develop, that it's not infringed upon and that they have the rights for that even in the future. That was really vital for us. Let's continue converging. Let's continue conversing.